Welcome everyone to the CAMCO Board Roundtable presentation. I'm Lorene Young. I'm a director here at CAMCO, and I'd like to thank you for joining. As you could hear, the meeting is being recorded tonight, and it will be available on the company's website and on the YouTube channel. If you could all please stay muted during this presentation, and we can have the questions placed in chat. And right now, I would like to introduce everyone to Josephine Wolf from Clemons, Richter, and Reiss. And she will be talking tonight, as you can see, about collections. So welcome, Josephine, and thank you for doing the presentation.
Good evening, everyone. Thank you so much for having me. I'm excited to talk to you about the wonderful world of collections. As Lorene mentioned, I'm with the law firm of Clemons, Richter, and Reiss. I am an associate attorney here, and I focus 99% of my practice on the collections work. So I am ready, willing, and able to talk to you about this topic. I am going to try my best to keep it to the 1 hour. I'm going to keep an eye on the clock because I could talk about collections for days, as fascinating as that sounds. All right. So as Lorene mentioned, if you want to put your questions in the chat as we go through, I'm going to save some time at the end for a little Q&A session. I do have a couple questions that were submitted ahead of time as well that I'll be going over. And just so everybody is aware, I'm a Pennsylvania attorney. I do not practice in New Jersey or Delaware. So the presentation is strictly with respect to Pennsylvania law and Pennsylvania procedure. If you have any questions regarding the collections process in Delaware or New Jersey, I would recommend you contact your association's attorney to have those questions answered. And a final warning, this is not to be construed as me providing you with legal advice. All right, so as you're probably all aware, there are almost 7,000 associations in Pennsylvania, and there are 1.3 million residents living in associations. And believe it or not, the total amount of assessments paid each year for condominium and community associations is $2.5 billion. So we're talking about a lot of money that's owed to associations. And when we have a lot of money owed to a particular organization, you're bound to have people who either choose not to pay or are not able to pay the assessments at one point or another in their ownership. So this is just a brief outline as to what I am going to go over. I am going to place an emphasis on foreclosures and bankruptcies today, as well as general procedure in terms of collection action taken by associations. All right, so firstly, and really most importantly, we recommend that associations have their own collection procedure policy in place. And in order to prepare that, you want to look at what's in your governing documents. Do you have any provisions that would require a certain late fee amount to be assessed? Does the board have any authorization to adopt a late fee that exceeds that amount? When do you consider an account to become delinquent? Is it after the first monthly assessment isn't paid? Is it after the second monthly assessment isn't paid? Are you authorized to seek acceleration for assessments due for the remainder of that fiscal year or for the next 12 months? What about attorney's fees and costs? Most governing documents in Pennsylvania do provide for that fee shifting provision that indicates if the association has to take collection action, the unit owner who is delinquent is responsible. And then when are notices sent to owners directly from the association? Whether that be by the association's treasurer or whether that be by your professional management company. And how many notices do you get before an account is going to be turned over to legal? So these are all really good inquiries you can go off of when you're crafting your collection procedure resolution. I hope a lot of you already have these resolutions in place. What it does is it protects the association, and then it sets forth what owners can expect in terms of any assessment delinquency issues. And the procedure resolutions are adopted by a board resolution. So that's a majority vote of the board pursuant to most communities' bylaws. And then they are published to the community as required pursuant to your bylaws, typically sent via regular mail, just like any other resolution. And you do have to make sure that these are followed. If they're not followed, then you put your collections attorney at risk for a potential Fair Debt Collections Practices Act if an account is turned over prematurely. And then, as with any resolution or anything adopted by the board, we certainly recommend that you review this with management and legal before you adopt it. Legal, you want to make sure that you're in line with what your governing documents already provide. And then you want to also touch base with your management company to make sure they are capable of doing what the board wants done. Can they send a certified mailing every month? Or does the management company prefer to send it via regular mail? So these are all just considerations to be made when you're discussing a potential collection procedure. Okay, and this is just something to kind of break up the monotony. I wouldn't really consider this to be an appropriate procedure. It might be effective, but not necessarily appropriate. Okay. All right. So another thing to consider in your collection procedure resolution is whether or not the association has the right to suspend privileges. You want to look at your governing documents, see if it's permitted. If it's not permitted, more recently, well, 2018, I guess it's not too recent, but in the legal world, that's pretty recent. The Uniform Planned Community Act, the Uniform Condominium Act were amended to permit suspension of privileges where there is an assessment delinquency. So some governing documents do provide additional restrictions. I do see a lot of documents that say, at least in terms of enforcement, if there's a violation of the rules and regulations, you can only suspend privileges for a period of 60 days. Obviously, that's more so a consideration for an enforcement procedure, but you still want to make sure there aren't any weird restrictions when it comes to suspension of privileges for failure to pay community association or condo association assessments. So some of the most popular rights and privileges are the right to vote, the right to serve on the board, the right to serve on a committee, the right to access the common elements, the recreational facilities and amenities. And I would say the right of access to the recreational facilities is probably the one that gets the most, the most response and the most consideration. Especially around the pool season, if your community does have a pool, everybody wants their pool pass, and typically in order to get your pool pass, you have to bring your account current. So that is certainly a season that we see a lot of people interested in paying their past due balances. And then another consideration is the right to make exterior alterations. I do want to caution communities that do suspend this right. If it's something that is a necessary alteration, for example, replacement of a window and the window's actually leaking, I certainly wouldn't recommend denying that type of an improvement, because it's not necessarily an aesthetic improvement. It is something that is necessary in order to protect the unit and then surrounding units potentially as well. All right. Now my favorite topic, the Fair Debt Collection Practices Act. So your legal counsel, your collections attorney is considered a debt collector pursuant to the federal law, because we are attempting to collect a debt owed to you as a third party, owed to the association. So before we can take any type of collection action, we need to send what's called a 30-day demand letter. It's a collection letter. And we need to include certain warning language. And there are some required disclosures that are involved in that. Very recently, as in the fall/winter of 2021, their regulations were actually updated, and there was a sample form released that essentially gives community association attorneys and other debt collection attorneys some safe harbor from potential claims if that form is followed, and all the calculations are correct as well. So we are limited in the way that we can communicate. We do not like to reach out to owners first. That just creates a potential issue. We don't like to communicate in ways that aren't authorized by the owner specifically. An example of that would be we send a demand letter, we don't get a response, but perhaps you have an email address for this person. We don't typically like to communicate that way because we don't know if this is a private email address. We don't know if it's shared, if it could potentially be just, other people could see it once the email's open. So, as I indicated, we're certainly limited in the way that we can communicate with people. Obviously, I think it goes without saying we can't use any harassment or abusive tactics. I don't think that would be a surprise to anybody on this seminar. All right. So when an account is turned over to my office, for example, we do look for a few things. And the first thing we do is we do an ownership search, and we make sure that the person's name on the account is consistent with who actually is the current owner of that property. We do a bankruptcy search as well to make sure there are no active bankruptcy matters. And then we do a mortgage foreclosure search just to see what the status is on that. So once the physical account is turned over to us, what we need to do pursuant to the Fair Debt Collection Practices Act is we need to make sure we can prove the entire balance. So we go all the way through the ledger. We make sure it goes back to a zero or credit balance. We want to make sure that any miscellaneous charges like chargebacks for maintenance, for example, are authorized by the declaration or the bylaws, or that they're permitted by law and that the owner was provided notice. With respect to fines, Pennsylvania law requires that anytime a monetary fine is issued against somebody, they are entitled by law to notice of that fine and what the violation is, as well as an opportunity to appeal that fine by requesting a hearing before the board. So those are the magic words that we're looking for when we look at fine notices. We want to make sure the owner knows what the violation is. They know that they have a right to appeal the violation at least one time. And we typically recommend that language is provided not in the courtesy notice or the warning notice that's first sent, but in that first notice that there is going to be a fine. The right only has to be provided one time for the same violation. I won't get too deep into that because that's more so an enforcement issue. But when it comes to looking at the account, we also want to make sure that we can prove how interest is calculated if there is interest on the account. As I indicated before, any self-help charges, we need to make sure they're authorized and the owner has provided notice of those. And then we need notice of any special assessments as well that were shared with the community. Okay, so this is an example of a collection letter that obviously would not pass muster pursuant to the Fair Debt Collection Practices Act. All right, and this is actually a sample of what was approved for use and what provides my office with some safe harbor. Obviously, we need to make sure that the balance is accurate, that everything that consists of the balance is authorized by law or your governing documents. And we need to make sure our calculations are correct as well when we're adding legal fees or interest. So that's the first half of it. And then here is the second half of it. We have gotten some responses utilizing this form, which is pretty helpful. The owners can, indicate why they want to dispute their debt. They can then attach a different, page or typewritten indication as to why they are disputing the debt. So we've been pretty successful, knock on wood, utilizing this form so far. And along with this form as well, we do include a full accounting that's attached to it. Okay, so let's talk about liens. So liens in Pennsylvania are a little bit different than some of our neighboring states. So the way that the Uniform Plain Community Act and the Uniform Condominium Act are drafted is that the lien is automatic pursuant to Pennsylvania law. And we need to enforce that lien by the filing of a complaint. So a lien does go with the unit, or also known as the real estate. So it follows the unit, but it's not necessarily against the owner individually. So a little bit more of an explanation of that is if there is a resale and perhaps you're in, the very beginning stages of collection, there's a balance on the account, then the owner is responsible for paying that balance prior to selling it to the new owner. Otherwise, the new owner would then be responsible for the lien, since the lien stays with the property. So technically, foreclosure is the way to enforce the lien, but in order to get to that point, we need to first file a complaint and we need to get a judgment. And these are all the magic Pennsylvania words. So, in order to execute on the judgment, and that's by way of a foreclosure, by way of a personal property levy or garnishment, we need to get a personal judgment in the Pennsylvania court system. So that can be with the magisterial district court, and those are essentially our lower courts in Pennsylvania, and their limitation is $12,000 in damages. In Philadelphia, that court is known as the municipal court, and then the common pleas court is the higher court. We go to common pleas where the damages are going to be above $12,000, or where we're having service issues in the lower court. Okay, and one big, proviso here is that there really is not a recognized procedure in Pennsylvania just to file a lien, and that really is because owners are entitled to due process. We have to prove the amount that's due and owing. It's not enough that we walk up to the courthouse, file a paper that says lien, that provides a specific amount. So the proper procedure in Pennsylvania is to file that complaint with the appropriate court, secure a judgment, whether that's by default or whether that's after a hearing, a trial, or an arbitration. Okay, so I went through a lot of this in the previous slide. And another note to make is that in Pennsylvania, there is mandatory arbitration for complaints that are requesting money judgments that are less than $50,000. So that's going to be, the vast, probably 99% of your collections. I don't see many balances that are reaching up to 50,000. Usually collection action is already taken at that time. And then once a judgment is obtained, then you can either execute on that judgment in the lower court, or you can transfer it up to the common pleas court and record it there. And that way it'll show up in, a credit check or a title search. And then judgments do expire after 5 years, so they have to essentially be renewed in order to maintain the priority. Okay, so getting into some execution options. So in Pennsylvania, one of the biggest questions I receive is, can we garnish their wages? And the answer is no. That's not an option in Pennsylvania, except for certain domestic obligations. But when it comes to money judgments, the law does not authorize us to garnish wages. But here are the options that we do have. So we can try what's called a personal property levy. And essentially that's when either the constable, if we're at the district court level, or the sheriff, if we're at the common pleas level, goes out to the property, knocks on the door, requests entry, and literally makes a list of the personal property located within the unit or outside the unit. This can potentially include motor vehicles. And then that inventory is then posted and they schedule a sale to sell the owner's personal property. Now, sometimes you might get lucky and you might have some property that's unique or that, sparks the interest of some collector or a third party bidder. Oftentimes the property isn't necessarily worth much, but the great thing about the personal property levy executions is it gets the owner's attention and it lets them know we have this judgment, we're going to keep trying to collect on it, and this is really our first step in doing that. I would say 8 out of 10 times it does result in the owner making a payment directly to the constable or the sheriff, or contacting my office to try to negotiate a long-term payment plan. So they're typically effective in that way. What happens sometimes is that the owner will tell the sheriff or the constable, you're not allowed in, I'm refusing entry, and we can then petition the court for what's called a break and enter order, which literally requests the court permit the sheriff to get a locksmith and gain entry via that locksmith without the owner's, consent, or without the owner letting them in. So that's really the personal property levy process. Really the goal there is to either get a payment, get some kind of long-term payment plan. I rarely see these actually go to a sale. Like I said, it's more so to get the owner's attention and let's get something paid. Let's get some kind of arrangement going for repayment. The next potential option is a bank account garnishment. And you have to do this at the common pleas level, the higher court level. So the bank is going to be served with paperwork from the sheriff, and then the bank's going to respond to my office or to your collections attorney's office and let us know how much is in this bank account. So the important thing to note, however, is that certain accounts are exempt from attachment. If you're getting any kind of governmental benefits, whether that's Social Security or disability, we cannot touch those accounts. Those are exempt. If you have a joint account for married individuals and only one spouse is a record owner, then we cannot touch that account either. Okay. And then another option is the rent garnishment. This obviously requires that the unit be rented. The tenant is going to be served by paperwork from the sheriff. And typically it's really helpful if we have a copy of the lease so we can see what that monthly rental amount is. And then some governing documents also permit an informal rent garnishment. So if you have a provision that allows the association to make demand directly on the tenant without having to go through the legal process, we can certainly start there. And then, our last option, and I know people have a lot of questions on this topic, is an association foreclosure. So this is when the association literally subjects a unit to the sheriff's sale, and third-party bidders can bid on that property. It's only done at the higher court, as you can imagine, at the common pleas level. And before we even consider an association foreclosure, what we want to do is get a title search. We want to look and see what are the prior liens on the property, as in what are the liens that the association is subject to, which is going to be your first mortgage. And it's going to be any governmental liens, any taxes that are due and owing. An example of this is, water, sewer liens, obviously real estate taxes, and then the sheriff's costs as well. So we want to figure out how much do we think this unit's worth. Another consideration is the owner still living in the unit? And do we think they're going to leave voluntarily if this unit sells? Because there is a potential that if, there's little to no equity and the association forecloses, there may or may not be any third-party bidders. So where there's no third-party bidders, the association then is going to take the property subject to costs. So then it becomes the association's responsibility to get this person out of the unit, which is going to require additional legal action to be filed and litigated potentially. As I indicated, we need to make sure there's sufficient equity in the property, and we need to make sure that the association is prepared and ready to potentially take title to the unit if there's no third-party bidders. Okay. And this unfortunately isn't an execution option, although I think it probably might be pretty successful, but that's not something that we community association attorneys do. Okay, all right, so talking about, foreclosures and mortgages and lien priority. So I did indicate that the association is by law and by statute pursuant to the Uniform Plan Community Act and the Uniform Condominium Act, subject to certain prior liens. So I indicated that the first mortgage is going to be prior to the association's lien, any unpaid real estate taxes, and any municipal liens that are on the property as well. The association is subject to all of those. So in a mortgage foreclosure, proceeding, it's a little bit different in terms of what associations can expect. And one of the big questions that I get is, how can we as an association, reduce our exposure where there is a mortgage foreclosure? And the hard answer to that question is it's very difficult to do so. But staying diligent and keeping, in line with what's going on in your community is certainly helpful. Monitoring these cases is certainly helpful. Letting your collections team know if you see something posted on the property, that's also helpful as well, so that we can then investigate on our own and see, is there an active foreclosure pending? But essentially, where a mortgage company is going to foreclose on the property, if the property does sell back to the mortgage company at the sheriff's sale, and that is going to happen if there's no equity in the property, if the mortgage company's judgment, for example, is either equal to or close to, what investors think the value of the unit's going to be, you're not going to get any traction at a mortgage foreclosure sale in terms of third-party bidders being interested. So in that case, if the property is taken back by the mortgage company purchases it for cost, the association is only going to be entitled to what's called the 6-month super lien. So that is all of the assessments that have accrued, assessments, fees, cost charges, during the 6 months that immediately precede the sheriff's sale. So essentially all other amounts that are due are divested in the foreclosure. However, there may be hope. If the property does sell to a third party, the association could potentially funds in excess of that 6-month super lien. That really depends on how much are the prior liens, and that's determined by the specific sheriff's department's title company. So what we want to do is we want to make sure that your law firm is aware of these foreclosures, that we're monitoring them. And if a property does sell, we want to make demand on the sheriff's department if it sells to a third party, in hopes that we get on what's called the schedule of distribution, and potentially get paid in full. It's a potential, but it's not a guarantee. So it does certainly require everything be aligned in favor of the association, and that there's sufficient money left over for the association to be paid its full lien amount as of the date of the sale. So then, let's say in a perfect world, the unit sells to a third party, there is equity, the association gets paid in full up until the sale date. So now, as soon as the sheriff's deed's recorded, your management company can then go ahead and open, a new account in the name of the new owner, and the new owner or the purchaser is going to be responsible for everything due as of, the date of the sale going forward. So an interesting question that also comes up is that third-party purchaser responsible for paying a capital contribution? And the answer is yes. A third party that purchases at a sheriff's sale, you can charge the capital contribution. It's actually just the mortgage foreclosure companies, the mortgage companies themselves. If they purchase at sheriff's sale, then they do not have to pay the capital contribution pursuant to PA law. All right. So going through, this is a little bit more about the mortgage foreclosure process. I just discussed, we split the account, and then if it's, sold to the bank, there is no capital contribution. And once, we are confident that it did sell to the bank, then we can reach out to the bank and request payment of that 6-month super lien, and then payment of assessments going forward. So the bank is also obviously going to be responsible for, once they take title to the property, they need to pay going forward as well, the regular monthly assessments, until inevitably the bank's going to resell the property. Okay. All right. So I also did already get into what to do if a unit's sold to a third-party bidder at the mortgage foreclosure sale. You want to make demand on the sheriff. You want to indicate that this is the total amount due and owing. However, if there's not sufficient equity, this is the 6-month super lien amount. You want to monitor to see when that schedule of distribution, it's called, is posted. The association does have 10 days to file exemptions or objections. An example of when that may be appropriate is if we're looking at the schedule of distribution itself, and at the bottom line, the owner of the property is getting some kind of refund. If the association isn't paid in full, those funds should not be going to the owner. They should be going to the association. So those are, telltale signs that we need to file exceptions and have the schedule of distribution redrawn and reposted. And then, if it's a third-party purchaser, as I indicated, you can collect the capital contribution from him or her, and you want to split the account as of the date of the sale. And we typically recommend waiting for the sheriff's deed to be recorded before doing that. Things can certainly happen. There can be objections to the schedule of distribution filed. There could be motions to set aside the sheriff's sale. So we want to make sure everything is final. We have a deed, and your management company can then have a deed on file as to who the new owner is and feel confident in splitting that account. Okay. All right. So a little bit of a subset of a mortgage foreclosure is going to be our short sales. And a short sale happens when a home is going to be sold for less than the amount due and owing on the mortgage. And this is typically where properties are quote unquote underwater, where there's no equity in the property. The amount owed to the mortgage company exceeds the value or the worth of the property. And this is really the owner essentially saying, hey, mortgage company, I know I can't afford to continue living here. I can't pay this mortgage. I'm in over my head. I can't really sell it to a third party because I owe more on the mortgage than I could sell it for ultimately. So they negotiate with the bank to essentially avoid having to go through foreclosure proceedings and the expense associated with a mortgage foreclosure proceedings. And frankly, the time associated with those proceedings, because it can certainly take at least 6 months to a year to get a mortgage foreclosure going, even if the owner isn't responding and everything is done by default. So in these situations, the association is going to be contacted by a representative of the mortgage company or the title company to try to negotiate what funds can potentially be paid to satisfy the association's lien. Now, as you can imagine, the first response from associations are going to be, well, we want to be paid in full. And the consideration to be made is that if, the short sale isn't able to go through because, issues with association assessments due and owing, then the association is now going to have to sit and wait for the mortgage foreclosure to go through. It doesn't necessarily make sense to expend, good funds in paying your collections attorney to go after these people after bad. You know that this property is underwater. You know that they're not going to be able to make any payments, and collection action ultimately is likely not going to result in anything, unfortunately. So, we certainly recommend being fair and negotiating these. If the property is truly underwater and it does go to foreclosure, the association would only be entitled to the 6-month super lien, and most likely, and in that case, then, we're subject to the additional assessments accruing while we're waiting for that foreclosure to happen if the short sale falls through. So those are just some considerations when you're met with a short sale request and you're met with, a specific amount that the mortgage company, title company is going to be willing to pay to satisfy the outstanding association judgment or lien. Okay. All right. So the next topic is a very interesting one. So with mortgage foreclosures, the mortgage company is required to notify all interested parties prior to the sale. So that would include the association. So the mortgage company is actually required to notify the association when a sheriff's sale is scheduled. They don't necessarily need to let you know when a complaint in foreclosure is filed, but they do need to let you know at least 30 days prior that there's going to be a scheduled sheriff's sale of the property on such and such a date. With tax sales, the procedures certainly vary from county to county, but the county is not required to provide the association with notice. So what happens is if, you see, a property that the assessments haven't been paid in quite some time, and this is really typical if there is no mortgage on the property, what your association attorney will do or should do is check the tax sale list to make sure that the property isn't on the list for tax sale. And as I indicated, you want to particularly pay attention to this where there is no mortgage on the property, because typically the mortgage company is going to pay the taxes even if the owner isn't paying the mortgage, because the mortgage company wants to protect its interest. So in most counties, if the taxes aren't paid for 2 years, then it's going to be put up for an upset sale. And if it's purchased at an upset sale, then the bidder takes the property subject to all liens and encumbrances at the time of the sale. And that includes the association lien if there's unpaid assessments, fees, and costs. So as I indicated, the notice of sale is really only by publication of this sale list. So, it certainly takes your management company or your legal team a little bit of due diligence to do a search and figure out if a property is on this tax sale list. And as I indicated, I can't say it enough, I think the main time that we see properties going up for tax sale is when there is no mortgage on the property. And that's actually, interestingly, the most popular time for an association then to go ahead and foreclose, because you don't have that big mortgage out there that the association's subject to. So it's, certainly important that even if the association is taking the stance of filing a foreclosure, that we let the tax claim bureau of that particular county know that there is a foreclosure sale. That way we're notifying every potential interested party. All right, so as I indicated, the first sale is an upset sale. If it doesn't sell at the upset sale, it will then be exposed for what's called a judicial sale. And in this case, the bidder is going to take the property free and clear of all liens and encumbrances. And this does require notice to all potential lien holders. So at least in terms of the judicial sale, the association should get notice in a perfect world, that this could potentially be sold at judicial sale. And I think the importance of keeping track is that the bidder is going to take the property free and clear, as I indicated, of all liens. Whereas at the upset sale, which is the first scheduled sale, the bidder takes the property subject to all those liens. So they would have to pay the association's lien to get clear title. And, we've certainly seen situations where people purchase a tax sale, the association, especially an upset sale, does not know it was purchased at upset sale. And the owner might then resell to a third party. That obviously creates a little bit of a complication. And if, those instances do occur in your community, I'd certainly recommend that you reach out to your collections attorney to get advice on how to proceed. Okay, so here's a little recap of what the collections process looks like. So first, you're going to hopefully refer all of your accounts to Clemons, Richter, and Reiss. And well, before that, you certainly want to make sure that all your in-house procedures, your collection procedure is exhausted. You did everything you're supposed to pursuant to your own internal procedure. And then once it's referred to my office, if we're satisfied, we can prove that underlying balance. We have all the backup for any miscellaneous charges, and the ownership information is accurate, then we're going to send a demand letter pursuant to the Fair Debt Collections Practices Act. So if the demand letter, we get no response and there's no payment, then we're going to file a complaint. So depending on the amount due and owing, if it's under $12,000, we'll be filing in the magisterial district court or municipal court if we're in Philadelphia. And if it's above $12,000, we'll file in the higher court known as the common pleas court. And potentially we could have a hearing or a trial. Most of the complaints filed in district court do go by default. So magisterial district courts have a default procedure whereby as long as an owner is served, if they don't respond to the complaint within a set amount of time, the court's going to automatically enter default judgment against them. And from that date of judgment, they have 30 days then to appeal that. Okay, so potentially we could have a hearing before the court. We could have a trial or an arbitration. And arbitration is mandatory in Pennsylvania for the common pleas court, so we have to at least start there. Okay, and then in a perfect world, we're going to obtain a judgment for the full amount due and owing, including all attorney's fees. That's in best case scenario. Okay, and then we can choose how we're going to execute on the judgment. Are we going to try a garnishment? Is there a tenant? Do we have a copy of a check, or are we going to start with a personal property levy? Okay, and then we could potentially move on to an association foreclosure if those initial execution options don't garner any payment or any response from the owner. And it's certainly important to note that in terms of my firm's status as a debt collector, we like to start with the less intrusive types of executions before we move on to association foreclosure. An association foreclosure is expensive, it's time consuming. The sheriff's deposit is pretty substantial. In Philadelphia and Bucks County alone, it's $2,000 you have to deposit with the sheriff, and that's just to list the property for sale. In Montgomery County, it's actually $4,500, and other counties it ranges from $1,500 to $2,500 as well. So it's a huge cost, and the association wants to make sure that they can potentially recoup that cost as well. The foreclosure paperwork also is time consuming because it needs to be precise and exact, and the forms and the requirements do vary from county to county. So it's important that you do have an association attorney who is familiar with different counties, and particularly the county that you're located in, what their procedures are in terms of foreclosures. Okay, so what could happen in literally the middle of any of these procedures is a bankruptcy being filed. That's what we're going to move on to. So bankruptcy, you could file a Chapter 7 bankruptcy, which is liquidation, which is essentially in most cases, you're giving up the unit, you need to sell it, you want to use the proceeds of the sale to pay off all of your debt. And the more popular filing that we see in the community and condominium association context is Chapter 13, which is a reorganization of your debts. So the importance, anytime we get notice of a bankruptcy filing, that is a big stop sign for us. There's an automatic stay. We cannot violate that automatic stay. If we violate it, we could potentially be deemed not only in violation of bankruptcy laws, but also that Fair Debt Collection Practices Act as well. So we can't take any further collection action once we get notice that there is a Chapter 7 or Chapter 13 bankruptcy filing. All right. So as I indicated, Chapter 7 is liquidation. Any unsecured debts are going to get discharged. Typically, the association is going to be a secured debt, especially if the debtor wants to continue living in the unit and they want to keep the unit. So pre-petition assessments are going to be a secured debt, which is great. So these are not discharged. And by pre-petition, I mean all the assessments due and owing prior to and as of the date of that Chapter 7 filing. So the post-petition assessments are a little bit of a different story when it comes to Chapter 7. So as long as, the bankrupt estate has some kind of an interest in the property, and a prime example would be they want to remain in the property and live in the property, then those assessments are paid. And, the old law is that if this is only if the debtor continues to reside in the property. The newer law is if they have any interest whatsoever, they need to pay that post-petition assessment. Okay, now the more popular filing is going to be our Chapter 13 filing. It's a reorganization. So the way that this works is that the association, as soon as it's notified that there is a bankruptcy filing, is going to let your collections attorney know and provide us with a balance as to what was due and owing at the time that bankruptcy was filed, that Chapter 13 petition was filed. And from there, we file what's called a proof of claim, which is an indication to the bankruptcy court that the association is a secured debt or secured creditor, excuse me, and this is the amount that's due and owing, and that amount is actually going to be included in what's called a Chapter 13 plan. So typically these plans are over a 60-month period they're paid. What is going to happen is a trustee, a bankruptcy trustee, is going to be assigned to this particular unit owner debtor, and all of the debt that's due and owing from all secured claims, which would include the association's claim, is going to be put in one big pot, and payment is going to be made to the creditors through this Chapter 13 plan. So a lot of the questions that we get is, when can we expect these, what's called pre-petition payments, the plan payments? What amount can we expect? Is there, a monthly requirement? And unfortunately, the answer to all those questions is it is in the discretion of that bankruptcy trustee. So as long as the association's pre-petition debt is paid in full by the end of that 60-month plan, we can't dictate how much we're being paid and when we're being paid. And I know that's difficult to hear, and it's nice to have that expectation of, well, the association is going to get X amount per month towards the pre-petition, but that's not something that can be guaranteed. The trustee has a lot of authority to issue payments as they see fit. And really the importance is the association is paid in full of that pre-petition amount at the end of the 60-month plan. And it typically is 60 months. Sometimes it's a little bit shorter. So it really depends on the income of the debtor, as well as their outstanding obligations in terms of the amount of debt. And then post-petition payments have to be paid when due. So post-petition is all of the monthly assessments due and owing after the date of the bankruptcy filing. So an example would be, say somebody files for bankruptcy today, March 23rd, they have to start paying April 1st if you have monthly assessments in your community. So the owner pays directly going forward. The bankruptcy trustee is going to pay for all that back due balance that's known as the pre-petition balance. And again, the bankruptcy trustee has a lot of discretion in terms of when and how much to disperse to each of the creditors. Okay. So if post-petition assessments, and that's the assessments that are due after the bankruptcy filing that need to be paid directly by the owner, if they're not paid, the association can potentially petition for relief from that automatic stay. And really that just means the association can tell the court the unit owner is not fulfilling their obligation, and we want to move forward with collection action. So a lot of times that this does result in some kind of a stipulation whereby the unit owner agrees to pay off the post-petition assessments within a certain amount of time. And the only option for collection, if relief from that bankruptcy stay is granted, is that the association can foreclose on the property. So that really is, it really limits the association's collection options. Okay, so we're definitely running out of time. So I'm going to run through payment agreements pretty quickly. We certainly recommend that if there is a long-term payment plan that is offered by an owner and accepted by the board, that the terms are clear. We want to make sure the owner is acknowledging what that balance is at the time. We want to focus on what's going to happen to any future late charges. Is there a soft cost waiver that's being agreed to? That would be, for example, a late charge waiver. We want to make sure that's specifically identified. We want to make sure that there's a provision that says if you default, the association can assess those charges right back onto the account without notice. And obviously you want to make sure that there's some kind of a provision in terms of what happens if there's a violation of the agreement. Okay, so, very quickly, I'll get through this in the next minute or so, but I was going to go through a little bit of a case study, an example, but long story short, we have two unit owners, Mr. and Mrs. Simpson. They live in Springfield Homeowners Association. It's located somewhere in PA. We're not sure exactly where. So they have, and the example is they haven't paid their assessments since May of 2017. your collections attorney is just being engaged now. So one of, the biggest considerations that we didn't necessarily address prior is how far back in time can we go to collect the assessments? Well, in Pennsylvania, the statute of limitations and the Uniform Plan Community Act and Uniform Condominium Act provide we can only go back 4 years. So if there has not been a complaint filed within that 4-year period, there may need to be a write-off to the account. So the answer to the question is we can only go back at this point really to today's date in 2018. So we cannot go all the way back to 2017 to collect. If we try to do that, arguably, we can be subject to a Fair Debt Collection Practices Act claim, and then there's going to be a defense that, it's part of the debt is outside the statute of limitations. So we did certainly go through the procedure and the process already. So how do we collect from the Simpsons? We file a lawsuit, we file a complaint, we get judgment, we wait for the appeal period to run, which is 30 days, and then we can decide how we're going to execute on that judgment. Okay, so service of process as well could be its own seminar here. But ultimately, district court, you need either in-person service by the constable or service by certified mail. And if we're not able to get service utilizing those means to get alternative service, which would be a posting of the complaint, for example, we need to move it up to the higher court, which is that common pleas court, to petition the court to allow that. Okay, so, at this point, say we get a judgment, there's no appeal. And the Simpsons want a payment plan. So we would recommend that you engage your collections attorney to draft a payment plan to make sure all, the recommended terms and conditions are in that plan. Okay. So then let's say the Simpsons file for bankruptcy. We need to immediately stop collection action, file the proof of claim with the bankruptcy court, and then, if this is a Chapter 13, we want to make sure they're making post-petition assessments. And that's something that, your management company can monitor, or you can request legal to monitor. Okay. And then if, for example, the Simpsons abandon their home, they just up and leave, they know that they can't afford to pay this. They are still responsible technically for anything that's assessed. Abandonment of the unit is not an excuse. You still need to pay assessments if you're the title owner. And then, considerations would have to be made if the unit's not being maintained. And that's a whole separate seminar. So I'm not going to spend any time discussing that. But if that does come up, you can certainly reach out to your legal counsel to see what options the association has. Okay, perfect. So we are at the Q&A portion now. So can everybody see the chat that I pulled up? Okay. So the first question in the chat is, what difference does it make if a unit is owned by a trust? So it doesn't necessarily make much of a difference, except in terms of how can we then go ahead and execute on a judgment that's entered. You can enter a judgment against a trust, a corporation, any type of business entity or non-business entity. So really, we just want to make sure that we know who to serve, which is typically going to be included in the Board of Assessments information and the deed. And then we can decide how to collect. I mean, in terms of, a property owned by a trust, we probably don't want to pursue a levy because, the odds are the property could potentially be owned by the beneficiaries and not the trust, personal property. There might not be a tenant. It might be the beneficiary of the trust in a unit. So a rent garnishment might not be an option. If we do have a trust payment, a copy of a check from the trust, we can still garnish on that trust account. And if, all else fails, then we could still proceed to foreclosure against a property owned by a trust. Okay. Another question is, so to garnish a bank account, does the judgment have to be over $12,000? No, the judgment does not have to be over $12,000 to garnish. It doesn't matter how much the judgment is, we can still transfer that to the higher court and we can proceed that way. So any judgment in the lower court can always be transferred in the higher court. And the higher court is just the place that we need to file for the garnishments. The district courts don't handle those kinds of executions. Okay. So the next question is, what impact is there on collection when a special assessment has been put on all the units in a condo? So a lot of times associations are going to see a little bit of an uptick in, necessary collection action when there is a special assessment. It also depends on the amount of the special assessment. Is this a one-time assessment? For an example, is this just a one-time snow removal assessment? Did your snow removal budget exceed snow removal expenses exceed what the budget was? So if we're talking about a more substantial special assessment, then we typically see a lot more, assessment delinquency in communities. But there really isn't an impact on collection. Collection of an assessment is the same, whether it's a regular assessment, whether we're collecting fines, whether we're collecting a special assessment. The procedure and process is the same as long as that special assessment is specifically authorized. Okay, I do have a question about New Jersey. I don't practice in New Jersey, so I can't necessarily answer that question, but I would certainly recommend that you address that question to your New Jersey collections attorney. Okay. So another question is, how can we get a list of any tax sales in our community? So what you can do is you can look at the Tax Claim Bureau upset sale. It's only once a year. So the sales are typically in the fall. So if you want to continue to monitor the Tax Claim Bureau website, they typically do post all of the properties that are up for sale. And they post a notice on the physical property itself. So if you happen to be walking around your community, you see there's a notice on the door of a unit that is delinquent, then you can certainly go up, look at the notice, make note of it, and let your collections attorney know what it says. Okay, so a really great question is, what happens if the unit owner passes away? And in that case, we monitor to see if there's an estate probated, and then we can essentially take collection action against the estate by serving the personal representative or the executor or executrix of the estate. Now the question is, what if there is no estate probated? Then your collections attorney is going to ask you, who is living in the property? Is anybody living in the property? Is it vacant? If there is someone in the property, we can try to serve the estate care of that person. If there's not, then it's going to take a little bit more time and energy to figure out who are the beneficiaries. If there hasn't been an estate probated and we're able to find, for example, an obituary, we can try to use that to determine who are the heirs, where are they located generally, and then we can go through the process of serving all the heirs. We certainly also recommend checking, is there a mortgage on the property, because the mortgage company might beat us to it. So a lot of times, if an owner does pass away and the assessments aren't being paid, then the mortgage probably isn't being paid to if there's a mortgage on the property. So we can either monitor for that mortgage foreclosure, we can see if there's a probate, and we can try to serve the heirs from there and get a judgment against the estate. Okay. All right. What is an informal rent garnishment? So an informal rent garnishment is essentially just a demand that's sent out to the unit owner, and that's referencing the portions of the governing documents that allow the association to collect unpaid assessments from the tenant. And typically your declaration is going to have language on this. It's a pretty popular provision for community and condominium association declarations. And it typically provides that the tenant is not responsible for paying anything in excess of that month's monthly rental installment. So we've certainly seen this be successful, and it's really, depends on if your tenant's going to be willing to respond to the association and to make those payments directly to the association as well. So it's really dependent on your particular documents. So if you do want to know if you have those provisions in place, certainly reach out to your collections attorney. Okay, another question is how can the HOA reduce exposure in the event of a mortgage foreclosure? And I think I addressed that question throughout the presentation, but ultimately just be diligent and make sure that you're doing, you or your management company or your legal counsel are doing searches to determine if there are any properties subject to foreclosure that are in collections. Okay, so I think I answered all the questions. Is there anyone that wants to ask a question not through the chat?
Yeah, we have time for maybe 2 more questions if you have another question. Otherwise, looks like there's one more that came through here.
Okay, all right. So the question is, so can we collect from a tenant without going through the process of filing a judgment against the owner? You technically can, as long as, if the correspondence is coming from the association directly, arguably you might not need your legal counsel to first send a formal collection letter pursuant to the Fair Debt Collections Practices Act. But if you want it to come from your association attorney, then they're going to have to, at a minimum, first send that collection letter first, and then they can send that informal demand to the tenant. It's not necessary that there is a judgment if it's permitted in your documents.
Okay, well, thank you, Josephine, and thank you everybody for joining. Really appreciate it. Our next CAMCO board events are April 5th. There will be a financial review for the boards. And on April 12th, there will be a board member orientation session, and emails will be sent around as reminders for both those sessions. So again, thank you all for joining and hope you have a good evening.